Okay, I think we're going to get started. I want to leave enough time for everyone to ask questions if you have them. So good afternoon, everyone, and welcome to our October installment of our Lunch and Learn series. Thanks so much for taking the time to join us today. We really do appreciate it. Today's topic is current changes to the Brown Act. I'm Gade Hamilton. For those of you who don't know me, I'm the paralegal on staff in the Legal Services Department here at CSBA. I'd like to introduce our fabulous team of attorneys who will be presenting today. First, we have Bob Turek, our Chief Legal Counsel, and also Senior Legal Services Attorneys Alex Worthy and Mariela Martinez. Okay, so of course, before we get started, just some quick housekeeping items I want to get out of the way. I want to let you know that this session is being recorded and will be available for viewing in the Legal Resources Library on our website. Again, if you have any issues accessing, please feel free to reach out to us. We are always happy to help you get into our library. We welcome any and all questions. However, we just ask that you mute yourself when you're not speaking. With that, please feel free to put your questions in the chat or use the hand raise feature, whichever you prefer. Like I said, there's going to be a Q&A session at the end of the presentation, so you can always ask your questions then. Also, I'll be sending out a happiness survey at the end after the session is over. So please just take a minute to complete that. We really, really do value your feedback. Okay, so I think with that, I'm just gonna go to our agenda here. Let's see. Okay, so let's look at today's agenda. First, we'll be talking about just quickly about the Brown Act basics, and then Berkeley People's Alliance versus City of Berkeley, and then we'll wrap things up with Senate Bill 707. And with that, I'm going to turn it over to Mariela to get us started.
Great. Thank you, Gade. And hello to everyone. Thank you for sharing your lunch hour with us to discuss these recent Brown Act changes. We always look forward to these, and I personally always enjoy seeing familiar faces, familiar names, and also getting to meet some of you that I've not come across before. So if we can move on to the next slide. Okay. So before we get into the changes that Gade mentioned, it's always helpful to provide a little bit of a background and context, and that's what I'm going to do with the next couple of slides here to start us off. As you all know, I'm sure the Brown Act is the most important open meeting law for local governments in California. And we have a quote here on the first slide right out of the Brown Act. And I feel that that perfectly captures the Brown Act's role and the reason why it exists and the reason why it is so important. I'll let you read it on your own, but you will note that it introduces some of the most important themes of the Act, that boards exist to aid in the conduct of the people's business, as well as that the people do not yield their sovereignty. So the concept of transparency becomes quite obvious here. Could we move on to the next slide, Gade? Thank you. So, and the concept of transparency continues on to this slide here. Again, I'm going to let you read it, but the keystone of the Brown Act is that all meetings of the local legislative body, such as the school board, of course, have to be open and public, with the exception of closed session, which are allowed for specific purposes only, as I'm sure you know. And having open meetings in the context of the Brown Act means that discussions must occur in front of a public audience and that the public must be provided with an opportunity to attend and participate. When you have this opportunity for public participation, as you can all imagine, and as we have seen, the chances for disruptions are high. And that's especially because we're talking about the future of our children. And we're talking about very charged topics oftentimes, as we have seen again throughout the state. So, with that, I am going to turn it over to Bob, and he is going to address just that, disruptions.
Thank you, Mariella. And if you guys have questions, anything about the Brown Act in general at the end, please let us know. But we wanted to make sure we reserve some time to talk about the changes specifically. Um, and as Mariella alluded to, really the changes are kind of about participation and disruptions, right? There's this case that I'm about to talk about that really directly deals with how do you address disruptions in the board meeting. And then most of the changes out of SB 707 have to do with access to the meeting, right? Which it's a transparency law, right? The whole purpose here is that the public has access to our meetings. But as Mariella said, along with that comes the potential for disruptions. Sometimes you have board members who don't behave well and they argue on the dais, but usually a lot of the disruptions come during the public comment period. Um, and as we saw, especially like during COVID, right? Then when everyone kind of became unhinged and we threw manners out the window and people yelled at each other over masks and all sorts of things, disruptions were really thrust into the spotlight. And so there were some revisions to the Brown Act. They gave us a little bit more guidance around disruptions and how we deal with them. You have always had the opportunity and the ability to address disruptors or remove people from a board meeting who are causing a disruption, but there wasn't really any language that helped us really know how to navigate that, right? It was sort of like this specter of something you could do, but how you actually went about doing that was a little bit vague. So what the legislature did was create a better definition for us here, which is up on the screen. It's at a government code 54957.95. And it defined disruption. Right? It gave us an actual disruption. What does a disruption mean? This isn't brand new, right? This has been in law for a couple of years now, but it's important to cover it so that we know exactly what it is we're dealing with. And a disruption is anything that actually disrupts or impedes the meeting itself, right? The actual piece is critical to this. It can't just be somebody being loud or obnoxious. It has to be somebody being loud or obnoxious to a degree that interrupts the meeting and impedes your ability to conduct your business as a school district or a county office of education. Next slide, please, if you wouldn't mind, Gabe. So, along with a definition, the legislature gave us a little bit of guidance, right? They gave us some guide rails as to what do we actually do when we have a disruption, something that's actually willfully interrupting our board meetings. And essentially, what the legislature said is what was already in law, but codified it a little bit more clearly, which was that you can remove individuals who are willfully disrupting a meeting, so that you can continue moving on with the business of the board. And this is the actual language that got challenged in the court case I'm about to talk about, Berkeley People's Alliance versus the City of Berkeley. Essentially, what happened in that case, right? The Brown Act applies to school districts, but it applies to all local government agencies, including city council meetings. And so, what was happening down in Berkeley is that in end of 2023, 2024, you had a series of meetings at the city council level where I believe it was three meetings, if I'm not mistaken, where a group, the Berkeley's People Alliance, were coming in and protesting. I don't know exactly what it was that they were protesting about, but they came to protest during the meetings. And their their conduct ended up interrupting the meeting, right? It was causing a bit of a disruption. They went about trying to stop the disruptions, but they weren't successful at doing it. And they felt they were no longer able to conduct the business of their city council. At the time, the mayor said that they were unable to restore order by removing any single individual or by having the room cleared. So, what they decided to do was adjourn the meeting to another location on site and continue there. Now, this is something that is, until this case, has been pretty widely advised as a means of dealing with disruptors, right? If you have one disruptor, you can warn them and remove them from the meeting. If the room gets out of control, you've always had the ability, and the law clarified a little bit, that you could clear the entire room. But for practical purposes and for safety reasons, that's not always doesn't seem intuitive, right? It's a lot easier for the board to get up and leave three, five, seven people and adjourn to a neighboring room and bring the media with them than it is to try and clear out 30 or 40 or 100 people who are angry. So it's been pretty common advice, pretty common practice that boards would adjourn to another location. Well, the plaintiffs in this case said, hold the phone, you're not allowed to do that. And I've got the language right there on the slide that they challenged. And as you can see in there, it says that if order cannot be restored by the removal of individuals who are willfully disrupting the meeting, the members of the legislative body conducting the meeting may order the meeting room cleared and continue in session. There's nothing in that language that says they may adjourn to another room. Now, remember, the Brown Act has notice requirements. They require you to post at the location where the meeting is being held, your agenda and notice of the meeting, all of that kind of good stuff that has to be on your agenda saying, this is where the public can access the meeting. So what the plaintiffs did was looked at this and said, this notice doesn't say anything about that other room. And there's nothing in the law that allows you to adjourn to another room. Clearly says remove a disruptive individual or clear the room itself and then continue in session. So they sued, and the lower court actually held in favor of the school district and said, well, that's not true. This is a practical thing. This is effectively the same thing to adjourn to another room as it is to clear the room, much like most of the legal advice that people have been giving on this point. But the plaintiffs didn't buy that argument. So they went ahead and appealed this, and the court used basically a statutory interpretation set of rules that's applied to all sorts of different cases. Basically, the court, whenever they're interpreting a statute, they look to what the legislature intended, and they defer to the language of the legislature unless they decide that the results would be absurd. That's actually the legal standard. So if we could go to the next slide. So the court looked at this, right? And they said, based on the plain language, and they used a dictionary definition of what does it mean to clear a room and remove an obstacle. There's no authority for a local agency, a local government body, to adjourn to another room that hasn't been properly noticed. So the Brown Act authorizes the legislative body to remove disruptors. It authorizes the legislative body to order the original meeting room cleared, but nowhere in the plain language of the law does it authorize a legislative body to recess the public meeting and reconvene in another room. Just on its plain face, and any other reading of that, the court said would be taking too much liberty with what the legislature had put into the law. Had they intended boards to have the ability to reconvene in another room, they would have clearly put that in the law. So Obviously, we know that the legislature sometimes it's hit and miss, so maybe that's what they intended, maybe not, but that's what the court decided. And so, contrary to what has been commonly advised, that is now the law under this new case, Berkeley People's Alliance versus City of Berkeley. So, where does that leave us? Gate, if you go to the next slide, it leaves us close to where we're at with one less option. So if you get a disruption in your board meetings, right, you still first have to warn the individuals. First and foremost, you must warn them. Your behavior is disrupting this meeting, and if you don't correct your behavior or stop disrupting this meeting, the board has the authority to remove you. Once you have given them a warning, if their behavior persists, you have some options in front of you. And I should note here real quick, if they're threatening violence, you don't have to warn them. You can just go ahead and have them removed because obviously safety comes first, right? But for anyone who's not threatening violence, you have to give them a warning. If they continue to be disruptive, you've got options. You can remove the individual. Again, safety first, and make sure whoever is actually doing the removal, that staff member or whoever is going about doing it, can do so safely. Your other option is to just go into recess. This can often be pretty effective, especially if you've got a group of people who are getting riled up about a particular issue. Go ahead and use the gavel, take a recess, take a quick 5-minute, 10-minute break, let people's tempers calm down, and then come back into the meeting. If the meeting is still in a disruptive state, if the board is unable to continue their business because too many people are upset, you can go ahead and recess the meeting again and have the room cleared. Those are basically your options. If that doesn't work for you, then your other option is to adjourn your board meeting to another day when there's less agitation going on in the board. So that's basically where we were left with the City of Berkeley case. I'm going to turn it over now actually to Alex so she can talk to you a little bit about Senate Bill 707 and what that means for giving public access to create disruptions. Or I mean to participate in your meeting, not to disrupt. Sorry.
Sometimes hand in hand. Thank you, Bob. Okay, so Bob just talked about how a case law has changed the Brown Act. I am going to talk about how a Senate bill has recently changed the Brown Act. So Senate Bill 707, if you enjoy reading new laws, then you will probably love this one. It's dense, it's thick, it's complicated, and parts of it impact school districts. It's a new law that was signed October 3rd. So it's brand new to this month. It is one of the most extensive changes that we've seen to the Brown Act in a long while. And much of the bill actually relates to cities and some other special districts, but there is a good chunk of it that applies to school districts and county offices, specifically related to teleconferencing. There are a couple other pieces as well that relate to school districts, but I'm going to be talking about teleconferencing because it is the most extensive changes that impact school districts. But before I kind of get into what those changes are, I want to talk about briefly just what the current rules are with respect to teleconferencing. So the Senate Bill 707 rule changes go into effect January 1st, but we're not to January 1st yet. So we do still have to comply with the current rules for the next, 2-ish months. And I think it's important to kind of understand for groundwork's sake what our rules are currently so that we can really understand what the changes will be come January 1st, 2026. Okay, next slide, please, Gabe. So what are the current teleconferencing rules? If you have ever had the pleasure of coordinating a conferenced meeting or being a board member who's teleconferenced, you probably know already that teleconferencing rules are pretty complicated. We currently have 4 methods in which a board member can teleconference into a board meeting. These are the four listed on the screen right now. We've got traditional teleconferencing, which is traditional because it's been in the Brown Act for a long time. It's not new, it's traditional, it's been there for a while. We've also got state of emergency, which is it came out of first Assembly Bill 361 and then 557. I only include the Assembly Bill numbers here on this slide for those of you who learned about these teleconferencing methods through the Assembly Bill. So just for context purposes, but we don't really refer to them through the Assembly Bill number anymore. But we've got the state of emergency, which is the situation where, everyone's quarantining because of a COVID outbreak, or we've got a fire or floods or other kind of emergency situation. So we've got state of emergency, it's a method of teleconferencing. And then we also have two methods that originally came from Assembly Bill 2449. We've got personal emergency and just cause. I will talk about specifically what these mean and how board members can utilize these. But generally, for the sake of, laying the groundwork here, when you're talking about a state of emergency, this is a situation in which the board needs to make a finding that meeting in person would be an imminent risk to the health and safety of attendees, and they're going to have to make that finding every 45 days. You may remember that because it's a continual finding situation. It used to be 30 days, and now it's 45 days. And then for personal emergency and just cause, these are the situations that are more specific to the board member. So personal emergency, meaning a physical or family medical emergency, preventing the board member from attending in person. And the board has to actually approve that request to participate via teleconferencing for that board member. And then just cause, under the current law, there's 4 reasons in which a board member can use the just cause provision. If you have a dependent caregiving need that requires you to appear remotely, or if you have a contagious illness, if you have needs related to a physical or mental disability that cannot otherwise be accommodated, or if you're traveling for official business of the board or of another state or local agency. So those are the reasons that you can currently use teleconferencing. But again, Senate Bill 707 has made changes to these in an effort to hopefully make this less complicated. But anytime there's new law, we have a period of learning. We have to understand what that law is. So maybe it's a little bit more complicated right now, but then hopefully after January 1st, it will be less complicated. So next slide, please, Gabe. Okay, so like I said, Senate Bill 707 goes into effect January 1st, 2026. It aims to simplify the teleconferencing options. And under this law, we will now have 3 methods in which board members can teleconference. The first, traditional teleconferencing, that has not changed. And I'll talk about that a little bit at the next slide. But traditional teleconferencing is the same. We've then got state of emergency, which is the same type of situation. It's a state of emergency or a local emergency. The entire board is going to be appearing remotely because of a fire, a flood, quarantining because of a COVID outbreak. It's that same situation. And in this case, for state of emergency, the board still needs to make findings that appearing in person would create an imminent risk to the health and safety of the attendees. And you are still going to need to make those findings every 45 days. There are a couple of changes with respect to now we can allow a 2-way telephonic communication versus like a live webcasting. So that has eased up a little bit under 707 for state of emergency. But generally, the concept of a state of emergency is going to be the same under 707. And then just cause is our third option under 707. And this is where we've seen the most change. So if you recall, under the current law, we have 2 reasons that a board member can participate remotely for personal reasons. So like personal emergency or just cause. Those were 2 separate ideas. Now under 707, they've been combined into a single method and they call it just cause. So now there are 7 reasons in which a board member can use just cause to appear remotely. So if you've got a child care or a caregiving need, and you need to participate remotely to make sure that you can fulfill that caregiving responsibility. If you have a contagious illness that prevents you from attending in person, that would be just cause. If you have a need related to a physical or mental condition that is not otherwise accommodated, that would be just cause. And I will mention here that if a board member can receive a reasonable accommodation, and that includes teleconferencing, then you should go through that accommodation process, and that generally would not be under the teleconferencing here. When I say, one of the reasons for just cause is a need related to a physical or mental condition that is not otherwise accommodated, typically that means it's like a short-term situation where you don't need to go through the full ADA accommodation process. That board member can appear telephonically or through teleconferencing under just cause. But if you've got an ADA accommodation situation, that's not going to be under teleconferencing anymore. That's a separate accommodation process. The fourth reason that you can use just cause now is if you are traveling while on official business of the board or another state or local agency. A question that we get a lot with that one is what happens if our board member works in the private sector but is gone for work a lot, is traveling a lot for work? Can they use just cause for travel while on official business? The answer is no. That travel piece is only if they're traveling for official business of the board or another state or local agency. So if you have a board member who works for a neighboring school district and is traveling because of their job with the neighboring school district, that would apply. But if you have a board member who works for Intel, for example, that's not going to apply. So be aware of that. We do get that question kind of a lot. The fifth reason you can use just cause would be if you have an immunocompromised child, parent, grandparent, grandchild, sibling, spouse, or domestic partner, and you need to appear remotely because of their immunocompromised status. Number six, another reason is if you have a physical or family medical emergency that prevents you from attending in person. That traditionally, under the current law, would be a personal emergency situation, but that's kind of the example of how it's kind of combined now into one method under just cause. And then the seventh reason is if you have a military service obligation that requires you to not be within the boundaries of the district and you need to remote into that meeting. So again, the general idea here is that just cause now includes some more options, some more reasons that you can utilize just cause. I am going to get into a little bit more of the specific rules in the next slide. But the idea, again, behind 707 is that hopefully this is going to make it a little bit less complicated. The rules now for just cause are going to be more streamlined, whereas under the current law, if you have like a personal emergency, the rules for personal emergency were different than just cause rules. Now we've kind of clumped them into one category and the rules are going to be the same for those. Okay, so next slide, please, Gade. I'm going to go into some of the specifics for each type of teleconferencing. And I should note too, if this is confusing, you are not alone. We are actually going to be putting together a guidance document that outlines all of the rules for each type of teleconferencing, when you can use each one, what you should be aware of for each one. And that is coming. So that's going to be available in our resource library. So if you have any questions in the meantime, before that gets released, please don't hesitate to reach out to us as well. Okay, so what are the rules for teleconferencing? Like I said, we have traditional teleconferencing. That has not changed. It's traditional in the sense that it's been in the Brown Act for a long time. This is the situation where you envision, that board member sitting in the hotel lobby, having posted the agenda at the hotel lobby, and members of the public can attend a meeting at the hotel lobby. That's the situation of traditional teleconferencing. Important thing to note here is that if you have a board member who is using traditional teleconferencing, you have to include the agenda at the location that the board member is going to be teleconferencing from. And so that in itself is a little bit clunky. A lot of times board members don't like to use that if they're going to be teleconferencing from home, because then the agenda is going to have the location of their home. And it's going to have to require that members of the public can attend the meeting from that board member's home. So it's, like I said, it's kind of clunky. It's not used all that often because of the requirements of traditional teleconferencing. But please note, you still can use it. It's still good law. But if you do, make sure that you post meeting notices and agendas at each location with the required notice period for the type of meeting that you are having. Additionally, like I said, members of the public need to be able to attend the meeting from that teleconferenced location as well. If you're going to be using traditional teleconferencing, you need to have a quorum present from the jurisdictional boundaries of the district or county office, and all votes do need to be done by roll call. For traditional teleconferencing, you can use that two-way telephonic communication. That piece is fine. You do not need to have audio and visual for that board member. Okay, so for state of emergency and just cause, the rules are a little bit different. Most importantly, this is everyone's favorite part. You do not need to include the location for the teleconferencing on the agenda. So if a board member needs to teleconference for just cause, or if you have a state of emergency situation, you do not need to include everyone's home address. If that's where they're teleconferencing from, you don't need to include that on the agenda. Members of the public do not need to be able to access that teleconference location to participate in the meeting. However, you do still need to provide the public with an opportunity to address the board in real time. That means through Zoom, if you use Zoom. Essentially, if you're going to allow board members to appear remotely because of state of emergency or just cause, you should also allow members of the public to participate in the meeting as well. A slight difference between state of emergency and just cause here is that under state of emergency, all that is required for the public is a two-way telephonic communication. I'm sorry, for the board member, two-way telephonic communication is required for state of emergency. Just cause does require both video and audio communication for that board member. So think like Zoom. So that's kind of one difference between the two. But importantly, members of the public need to be able to access the meeting in real time. They need to be able to participate in the meeting as well. You know, you can't just stream the meeting on YouTube and call that participation. The members of the public actually need to be able to make comments live in the meeting, participate remotely. The board cannot also require comments to be made in advance of the meeting. So that's another piece in there as well. There is a limited number of uses that board members can use just cause. So that limitation is 2 times per calendar year if your board meets once per month. If your board meets twice per month, a board member is limited to 5 times per calendar year. So again, all of these nitty-gritty details are going to be outlined on a guidance document that we will be putting together and will be available on our resource library as well. Okay. One important piece here that 707 changed, which is, I think, really helpful for board members, is that if a board member needs to use just cause to participate remotely, under the current rules for personal emergency, which again now is combined into just cause currently, under personal emergency, the board used to have to approve that. So the board could theoretically say no, but currently under 707, so starting January 1st, it no longer needs to be approved by the board. All that is required is that the board member just notify the board that they're going to be needing to use just cause as soon as possible. Another thing that's important to note is that, you know, when we're doing Zoom meetings like this, obviously you're seeing me and my screen, but you're not seeing anything else in my room. Theoretically, if you have someone sitting in the room, that would kind of run contrary to the idea of confidentiality if you're in closed session, or the idea that other members, other people, not board members, would have access to information. So the Brown Act, now under 707, and it was also under the current law as well, it requires that if you have individuals who are over 18 years old present in the room with you, you need to announce that before the board takes any action. So you need to announce that you have someone over 18 in the room with you, and you need to state the nature of their relationship. So for example, I have my 18-year-old child with me in the room, because they live in this house, or whatever the case may be. So you will need to announce that before the board takes action. Another change under 707, they specified here that if the board has a specific period of time for public comment, and you're allowing participation via teleconferencing because of the provisions under state of emergency or just cause, you cannot truncate or you cannot end that public comment period before the time that's specifically outlined in the agenda. You do also have to provide reasonable time for members of the public to register if they're using Zoom. Sometimes you have to go through a period of updating Zoom or registering your name via Zoom. You have to give people reasonable time to do that. And you can't cut off the comment period before the time has elapsed if it's indicated as such on your agenda. A question that actually comes up quite often, what happens if the Zoom connection or whatever technology you're using, if the disruption becomes disconnected or disrupted in some way, the board actually cannot take action until that access is restored. So if you have a Zoom meeting, for example, and then all of a sudden the members of the public, the access is disrupted and they can't participate in the meeting anymore, you don't have to pause the meeting, so to speak. You can continue discussions. You just cannot take action until that access is restored. The same is not true, interestingly, if a board member's access is cut off. It's really the key here is that members of the public, their access cannot be cut off. Okay, and then lastly here, all votes do need to be conducted via roll call as well. Okay, and I see that we have a question. When does a board use regular teleconferencing if the other options are for just cause or emergencies? I apologize if, oh, okay. No, that's a great question. So let's say, for example, I mentioned previously, if you have a board member who travels a lot for work because they work for Intel, for example, they could theoretically use traditional teleconferencing. That wouldn't be a situation where the travel would be under the just cause provisions under the current or under 707. But you could use traditional teleconferencing for that. Again, you will have to follow those specific rules under traditional teleconferencing. So they're going to have to, know where they're going to be at the time. So if they're traveling for work and they're going to be at a specific hotel room, or a hotel, they're going to have to contact the hotel ahead of time to post the agenda. And then they're going to have to decide if they're going to have members of the public attend in the lobby or their actual hotel room, which is not great. So it is clunky. There are rules that they have to follow. But if you have a situation where someone needs to teleconference and it's not included under just cause, then that's when you can use traditional teleconferencing. Okay. Unless there are more questions about that right now, I'm going to turn it over to Mariella, who's going to cover an additional change under 707. And then, of course, we can take more questions at the end as well.
Great. Thank you, Alex. Like Alex said, we're going to wrap up today with a discussion of online disruptions. And that obviously ties together the concept of disruptions and that Bob discussed, and then remote access to meetings, which Alex was discussing. So this is also 707, goes into effect January 1st, 2026. And like I said, Bob talked about disruptions in the boardroom. And as he mentioned, the law as it is today authorizes the president of the board to remove or cause the removal of an individual for disrupting the meeting. And existing law also defines disrupting for these purposes to mean engaging in behavior during a meeting of the board that actually disrupts, disturbs, impedes, or renders infeasible the orderly conduct of the meeting. Again, something that Bob mentioned. So, what does this portion of SB 707 do? It specifies that a meeting for purposes of that provision, the provision of disruption, includes any teleconference meeting. So the existing authority of the board or its president to remove or limit participation by persons who engage in behavior that, again, actually disrupts, disturbs, impedes, or renders infeasible the orderly conduct of the meeting applies to members of the public who are participating in the meeting via a two-way telephonic service or a two-way audiovisual platform. This makes a lot of sense, of course, and it's now part of the Brown Act. So the same applies whether you are appearing in the boardroom or whether you are appearing through a telephonic device or an audiovisual platform. With that, I'm going to open up our Lunch and Learn to the questions that you may have regarding anything that we have discussed thus far.
And I do see that there's a question in here. What if the board member is just on vacation? That's a great question. They can use traditional teleconferencing if they're on vacation. But one thing that we always want to mention too is that board members are also allowed to just be absent. If you're on vacation, you can just be on vacation. That's totally fine. You can miss a meeting. But another piece with the vacation, I think it's going to depend too on what that vacation is. So if you are, just going, 20 minutes away and you're going on vacation, like a staycation somewhere close by, that's going to be a lot easier. But if you're going on like a cruise ship, for example, members of the public are not going to be able to access that cruise ship. So you're going to have a hard time complying with the traditional teleconferencing rules to, post the agenda ahead of time, allow public access to the meeting at that teleconference location if they can't even get on the cruise ship in the first place. So again, you can use it for vacation. That's a possibility, but there are some additional things you'll have to think about. And the idea that board members can also just miss a meeting if they're on vacation is fine too. Good question, though.
One thing to
Okay.
note on that also, if they are on vacation and they're using traditional teleconferencing, still has to be from a freely accessible place, right? So we always use the cruise ship example. If you go on a cruise ship, you cannot teleconference in from there under any of these methods because it's not freely accessible, right? Unless it's a free cruise and then I'm coming with you.
Okay, then the next question, did you mention that ADA accommodations do not fall under just cause anymore? Yeah, that's a great question, and that's something that 707 specifically carves out. So you can accommodate board members through the ADA accommodation process, and if that means that their accommodation is teleconferencing, then you can do that, and there wouldn't be any limit restriction on that as there would be under just cause for teleconferencing under 707. So when you have a situation where someone is, maybe they have a temporary situation, maybe they break their foot and are unable to attend a meeting, you can use just cause for that. It's kind of short term, that's fine. But if you have an accommodation request that is kind of more of a long-term situation, that would not fall under 707. You would not need to comply with the limitations, that 2 times per calendar year if you meet once a month, that kind of thing. Your accommodation process would be separate, and you can accommodate board members for teleconferencing if that's what an accommodation works best. What if that accommodation is what works best for them? That's a great question. And another question here. They cannot call in from their car while they are driving. So if you're using traditional teleconferencing, that is correct. You cannot call in from your car if you are driving because members of the public would not be able to access your car, especially if it's driving on the freeway. That would be kind of a funny situation to see that happen though. That is correct. If you are doing a situation where you've got just cause or state of emergency, as long as the board member for state of emergency has a two-way telephonic communication, that's fine. And for just cause, if they have audio and visual working, that's fine. If they're driving, they probably should not have audio and visual going on, so they should probably pull their car over. But technically, those are the rules there. So good question.
Okay, any more questions? All right. And if you do have questions, go ahead and just reach out to us um, individually or as a team to our website. Um, so if there is nothing else, attorneys, do you need to say anything else? Or should I let them go?
Just thank you all for joining us during your lunch hour.
All right. Okay, just a quick reminder, please complete the happiness survey when you get a chance. And we will see you at the next Lunch and Learn. Thank you so much for joining us. We really appreciate it.